Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Where the heck am I? This is Billings, Montana. Hey, what are we going to talk about today? We're going to talk about some really good news from the United States Supreme Court for once. That is that the United States Supreme Court has, in fact, accepted review in the matter of Garland v. VanDerStock, formerly known as VanDerStock v. Garland. What is that case? I know it's hard to keep track of all of them. Well, that is the case that deals with unfinished frames of receivers, or what you like to sometimes call 80% lowers. Listen, this is yet another opportunity for the ATF to get reined in. This is a wonderful opportunity for gun owners nationwide. So today, let's get you all updated and let's talk about the Supreme Court to answer the 80% lower question. Okay, hey, before we get going too far down the road we're going down, proud to announce that this video is being brought to you by the Mantis X10 Elite Training System. Listen, we preach all the time here about lawful and responsible gun ownership. What does that mean? It means you need to be confident, you need to be proficient in the use of your firearm. It means that your groups should look a little like this. Unfortunately, if you're honest with yourself, you know your groups are looking a little bit more like that. But do you really have the time and money necessary needed to train at the range all the time? Well, that's why you can train confidently at home, save thousands on ammunition, and avoid range douches like this guy right here. And did you know that 94% of all shooters improve within just 20 minutes on the Mantis X10 Elite? Listen, the Mantis X10 Elite is used by the United States Marine Corps, the United States Army, and Special Forces. And here's the cool thing. The Mantis X10 Elite, well, it works with just about every platform of firearm. So whether you're firing a pistol, a rifle, a shotgun, or even archery, Mantis X10 will make you better. And here's the best part. All you need is the Mantis training aid and a smartphone with the app already installed on it. And the app's the best part because you're going to get free updates for life. There's no subscription. It will store all your data. It will even allow you to build groups so that you can share data with your friends to see who's doing better and who needs to keep working. And come to think of it, it would make a great Father's Day gift, wouldn't it? Because after all, Dad's got enough ties already, doesn't he? So listen, if you're ready to take your training to the next level, or you just want to do something really cool for Dad this Father's Day, click on that link right there, or for more information, visit my good friends at MantisX.com. Okay, America, this is what we're talking about today. We were talking about news last week that the United States Supreme Court has granted certiorari in the case of Garland v. VanDerStock. Now, this was a challenge to a rule that was published way back in 2022, ATF's rule on unfinished frames and receivers. And as you recall, it created this spectrum where somewhere along this spectrum, a piece of material went from just raw material to somewhere close enough in resembling a receiver that the ATF felt that they had the authority to regulate it. This, of course, all despite the fact that the United States Congress had never enacted any type of legislation to make this possible. Now, this case, as you know, was a victorious one down in the lower courts in the Fifth Circuit. And so this marks now the third time that a case has been accepted by the United States Supreme Court post-Bruin that involves Second Amendment issues. And I should point out, and maybe some of you might be worried about it, this is also the third time that this has been done at the request of the United States government. So far, we have 3 Second Amendment cases post-Bruin that have been accepted by the United States Supreme Court, all 3 of which were actually at the request of the United States government. So I want all of you to understand that much like the bump stock case, this case doesn't have a lot to do with 80% lowers or unfinished frames and receivers. In fact, in many ways, it's a mere footnote to what we're talking about. Because what this is really about is whether or not we're going to allow the administrative state, that fourth branch of government, those executive agencies, to go out and continuously write new rules that suddenly turn individuals into criminals overnight without ever having an act of legislation come out of the United States Congress. And so this case, along with the Cargill case now, is 2 huge questions as to whether or not we're going to allow these administrative agencies to continue this course of conduct, or is the United States Supreme Court going to finally step in and uphold the separation of powers doctrine upon which this entire country was founded? Take, for example, what Second Amendment Foundation Director Adam Kraut had to say about this exact case. We have 3 separate branches of government, executive, legislative, and judicial, and an agency within the executive branch simply cannot make up its own rules or change them arbitrarily, especially when it involves the exercise of a constitutional right. Authority to regulate firearms is solely in the hands of Congress, not an executive agency, which is what this case is really all about. We're looking forward to making argument in October. Okay, so to give you an idea of what we're looking like for a timeline on this, the United States government's brief is due June 25. That is, the ATF's opening brief in this matter must be filed with the United States Supreme Court by June 25th. So Second Amendment foundations and all the other respondents' briefs will then be due August 13th. So we're going to be getting videos out late June when we see what the United States government has to say about this. And we'll also be getting videos out in mid-August when we understand what the Second Amendment Foundation and all the other warriors in this case have to say about it. Oral argument on this case is tentatively scheduled somewhere between October 7th and 9th this coming fall, which means we do anticipate rulings on this case sometime in the early summer of 2025. Okay, the case once again is Garland v. VanDerStock. We're going to link it up down below. Now remember, this case is brought to us by our good friends at the Second Amendment Foundation, which means we're going to put a link down below so all of you could show them some love as well. By the way, if you got any ideas for videos we should be doing here at Washington Gun Law, go ahead and click on that link right there, because some of the best videos we ever did weren't really our ideas to begin with. If you got any other questions about this case or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information is down there in the description box. And then finally, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. From beautiful Billings, Montana, thanks for watching and stay safe.